Welcome back to another episode of Law Schoolers. We're continuing to discuss secure transactions, and in this episode, we're going to be talking about enforcement and full and partial acceptance of collateral. What do I mean by this? This is when collateral, receiving the collateral, the creditor receiving the collateral, is enough to satisfy either fully or partially the debt that the debtor had and had put that collateral up as a security against that debt. So full and partial acceptance of collateral is going to be outlined in Articles 9, Section 9, 620 through 622. Sometimes a creditor may want to retain the collateral instead of selling it and extracting the value to satisfy the debt. And that's really what we're going to be focusing on here. When will the creditor want to retain the collateral instead of selling it to satisfy the debt? Well, acceptance in full, let's start there. If a creditor wishes to accept collateral to satisfy a debt, they need to obtain the consent of the debtor. As such, the creditor is required to send the debtor a proposal which will outline that the creditor wishes to accept the collateral to satisfy the entirety of the debt. Again, acceptance in full, which means we will take this collateral and it will cancel out all of the debt that you have against the creditor. In this situation, the debtor does not need to send an authenticated consent form for the proposal to take effect. If the debtor fails to make a timely objection, the proposal can be seen as accepted. As such, creditors often include a date by which the proposal will become effective, and failure for the debtor to object before that date will ultimately result in an effective agreement. In the proposal, creditors will also say that the proceeds are to be included as acceptance. That way, the debtor is unable to extract the value of the proposal before it goes into effect, and therefore leave the creditor with valueless collateral. What am I trying to say by that? Essentially, sometimes the creditor will give this notice, and a debtor is seeking to extract as much value out of it as possible before giving up the collateral, will deplete the collateral, extract its value, and then seek to retain its value, and then only give up the, so to speak, body of the collateral, whatever that might be. This notice, by saying that proceeds are to be included, and therefore would mean that you can't extract this value as a debtor, and ultimately the proceeds that the debtor ultimately extracted from this would also be required to be paid in exchange for satisfaction of the debt. So, acceptance in full ultimately means we will take the collateral and accept it, and that will satisfy the entire debt. Now, what this also means too, this could be good, this could be bad for the debtor, and that's why you need to get the debtor's approval. It could be good for the creditor because if the value of the collateral is more than the debt, and then the debtor consents to using the entirety of the collateral instead of selling it, well, now the creditor might have more value than what the debt previously was. Now, it could also be a con for the creditor as well if the value of the collateral is depleted and the debt exceeds the value of the collateral. Then that might be a situation where the creditor might not want to accept the collateral in full. And if that's the case, then partial acceptance is ultimately going to be the next step that goes forward. The main difference between acceptance to fully satisfy the debt and partially satisfy the debt is the manner of consent. Acceptance to partially satisfy the debt requires an authenticated consent of the proposal by the debtor. And the reason for this is because partial acceptance, you still have a debt. And so if you still have a debt, and then the debtor needs to approve to still having this debt. Failure to obtain this consent will require the creditor to follow regular foreclosure procedures that we had talked about in the previous episode, which is recovery, assuming recovery has not happened yet, and then disposition by providing notice and conducting the sale within reasonable standards, reasonable commercial standards, and then paying off the proceeds as outlined by who has priority. A couple other notes that I want to bring up before closing this episode is that a creditor can hold on to the collateral for a long time and it will not be considered as accepted until a proposal is sent out. So, debt still remains, you can recover. It's not considered accepted until the proposal to count as accepted is sent out or the sale occurs. Second note, acceptance of the collateral by a junior secured party does not diminish the rights of a senior secured party. That is, the collateral is still utilized to secure the senior party's interests. And then the third note is that no notice is required to be provided to secondary obligors. And we will talk about secondary obligors in our next episode. All right, that's everything that I have for this one. Pretty brief. We have one more episode of Secure Transactions, and then that content will be wrapped up, and we'll move on to another course. All right, thanks for listening. Have a good one. Bye. Thank you for listening to this episode of the Law Schoolers Podcast. If you enjoyed the show or the material shared on the Law Schoolers website, you can support Law Schoolers by becoming a patron at patreon.com/lawschoolers. I also wanted to provide a quick disclaimer. Nearly all Law Schoolers material is unedited due to the sake of time and a desire to keep the content as raw as possible. Additionally, the material is only provided for educational purposes and is not to be used as legal advice. If the material is used as legal advice, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show.